We thought we'd explore how and whether privacy rights are holding up under the AI onslaught, and I think we have the perfect guest. Daniel Solove is a leading expert on privacy law, a scholar who's written a number of articles and books on the topic. Professor, welcome to TalksOnLaw.
Thanks so much for having me.
And did I read that you're the most cited academic scholar of your age, at least?
Yeah, they did a scholars born after 1970. So I can't compete for people older than me. So they called me a young scholar, which I kind of like.
I love it.
It's rare that I've been called young at this age, at this point.
And am I right that every time you're cited, that comes with a large payment?
I wish. It's just mainly just nice to see myself cited, but yes, I do not get any, I don't get anything for it.
Well, we'll be getting into the details, Professor, but, we're talking about a lot of new tech. It just feels like at this time, technology is moving on a pace like we've never seen before. Is our constitutional privacy right, is it keeping up? Is it what it used to be?
Well, no, and I don't think it's ever really kept up. I think the law has not generally done a good job of protecting privacy. And especially, I think, when it comes to the Fourth Amendment to the United States Constitution, which is the amendment that regulates government searches and surveillance. And that has generally, I think, failed pretty miserably for quite some time. And it's improved recently a little bit, but generally, I think if we look at the history of it, it's unfortunately been not meeting the task for modern digital technology.
You famously said privacy is a concept that's in disarray. Is that what you're getting at?
Yeah, well, the concept is in disarray because for a long time, no one's really been able to pinpoint exactly what privacy is. And I think that unfortunately, when we look at courts and policymakers, they just have very antiquated notions of privacy, notions and ideas of privacy that I think are overly narrow and that are not really responsive to the technological world we're living in today.
Maybe this is a good time to point out that our privacy right is vis-a-vis the government. And I say the government is singular, but state and federal. We don't have a privacy right, particularly against Google or against OpenAI.
Well, we have not a constitutional right. So the Constitution gives us individual rights vis-a-vis the government. So if the government wants to do something, gather information, engage in surveillance, we have constitutional rights to purportedly protect us from that. Unfortunately, they haven't done that very well. But we also have statutes and other laws that protect us and that give us. So there are statutory rights to restrict government data gathering. And those statutes, unfortunately, I think were violated when Doge went and gathered all our personal data and used it in ways that are inconsistent with a federal privacy law called the Federal Privacy Act. There's also state laws that provide privacy rights, and also people can sue for privacy violations under some laws. And these laws do, in some cases, regulate companies like Google and provide us with protections against those companies. Unfortunately, a lot of those laws are pretty weak. And in a lot of cases, there are a lot of practices that companies can do that really get very minimal protection under the laws. And I've long argued that, not only should they get protections under the existing laws if they're interpreted properly, but there also needs to be additional laws and stronger laws to better protect us against information gathering by Google and these other companies, because one thing I've written in a recent article, it's called Privacy in Authoritarian Times, is that there's a key relationship between what the government can gather about people, the information the government can gather, and what's sort of now known as surveillance capitalism, which is what companies can do and what information companies can gather about people. And for a long time, the libertarian position was, well, we want to stop government surveillance, but we don't want to regulate the private sector. We want to hands off the companies, but let's focus on the government. That's the real privacy problem. It's Big Brother. But I think that in today's age, there's a increasing relationship between the government and companies. There's a collusion going on. And you can't really regulate government surveillance without regulating surveillance capitalism, without regulating the private sector and the information they have. And we're seeing
That's
this really
interesting.
play out right.
Is it i- is part of your argument that it's sort of outsourcing the job?
Exactly. Right now, that the government can gather all the information from the private sector. So most recently, I think the headlines are that the government is gathering all sorts of data about people's location and activities from data brokers that gather information from apps people use and other things. The Supreme Court has said in a case that's about roughly 10 years old or a little, something around there, that, location data is protected by the Fourth Amendment. So the government would need a warrant to be able to get your GPS data or your cell phone location data. However, the government now has done an end run around that and is just saying, okay, well, we're not going to get it from your cell phone provider. We're going to get your location data from apps and other things that are tracking this information.
Interesting. So if
And
it
when
was
you
so private, why did you share it with Google Maps, or why did you share it with, name your restaurant app of choice?
Exactly. And a lot of these apps are tracking your location and you have no idea that they're doing it. And the amount of information being gathered by all these different companies is staggering. And then these companies sell it to others, and data brokers sweep up all this data, buy up all this data, and then compile profiles about people with the data, and then they market it and sell it to the government.
So the government isn't mandating that it be handed over to them in every case. Sometimes they're just literally going through the same channel that a shoe company would. They're purchasing it.
Exactly. The problem is that the data brokers market it to the government. So, they kind of, they're a very big customer for the data brokers is the government.
Wouldn't you like it if you could do this? How about we sell it to you?
Yeah, well, I mean, you can go and buy it. People can buy this information. It's very easy to gather, and I mean, it's very easy to get and buy personal information about anyone. So yeah, I can buy personal information about you. Anyone can. I could be doing it because I just want to know more about you and your life, or I could be a deranged stalker and I want to attack you or find out where you live or harass you, and I can go and gather the information as well. Once it's out there and it's being sold, I mean, anyone can buy it for any purpose.
Well, I think you just answered part of that question, but the question that I want to ask, but let's ask it anyway. What about the argument, hey, if I've got nothing to hide, why do I care? I mean, maybe I'd be better off if more of this information was out there.
Well, this is often made, this argument I wrote about how often people will say this, oh, I've got nothing to hide. But that's a particular narrow view of privacy. It views that privacy is only about hiding things. But I think privacy is much more complicated than that. So, for the most part, like I don't want to hide where I live. I'm okay. But I do want to hide it from a deranged stalker. If someone wants to harm me or my family, then I do want to hide that. I for a lot of people, it's not so black and white where, okay, this information is totally fine or totally not fine. We share information in context. And so someone might say, look, in private, they criticize their boss. They're happy with their friends knowing it, with their family knowing it, but they probably don't want their boss to know it. And they might say, I have nothing to hide. But then, yeah. And when they're fired because they said something that their boss was an idiot, then, they'll probably rethink that. And so this is the challenge is with privacy is that it's really about,
Or they're fired because they say something political that their boss doesn't agree with.
exactly. I mean, these days, the landscape has really changed with information where, it used to be, I long for the days where I could buy a pillow and my pillow doesn't have politics, or I could eat a chicken sandwich and not worry about, like, is it a Trump sandwich or is it a Biden sandwich? There used to be that day, but now everything seems to be politicized. The information and the things that people buy and all the things that people do in today's day of AI can give rise to inferences that people don't expect. So, there's a famous story where people were like shopping at Target and they were just buying, everyday products. They didn't realize that Target had an algorithm that was trying to figure out if they were pregnant.
This was
And
such a fascinating case.
yeah, and the algorithm, from purchasing, I think, unscented products and cotton balls determined that people were pregnant. And so people are like, I don't have anything to hide because I'm just buying unscented soap, cotton balls. What am I revealing? But they didn't know that the algorithm said, oh, actually, you are revealing that you're pregnant. You're revealing sensitive health data. And that's going to be the case with a lot of things that people think, oh, this is what I think I'm exposing. But they don't realize in today's age that the algorithms can look at that data, analyze that data, and then determine their religion, their political beliefs, other very sensitive information, their health.
Yeah. I mean, Professor, are you using any of these chatbots like ChatGPT or Gemini or Grok?
Yeah, I mean, I've tried them out. I play around with the AI, partly because that's my career. It's to kind of learn like what they do and experiment with them. I think they're interesting, and I think they do some interesting things. I also think there's a lot of misunderstanding of them and a lot of overhype of them and misuse of them.
Well, I was just going to make the point that they know a lot more than Target knows I want Q-tip or cotton balls and unscented soap. A lot of people I know are telling it their biggest problems and their psychological trauma and whether or not they should escalate things within their relationship. So it's access to a whole nother level of information.
Yeah, and I think they create several problems. One is the access of information, the privacy issues. There's also issues with regard to, what information they're getting back. And so people that use a chatbot for their therapy or emotional support are, now there are issues where the chatbots are not necessarily giving the best advice and are giving them very bad advice because they're not you know, they're not infallible. They're not necessarily well designed for the purposes of that use.
Let's get back into privacy. Why don't we start with what the Supreme Court has said on privacy? I know you could teach a whole semester on this, maybe even multiple semesters on this, but can we get an overview on privacy law, maybe a couple of highlights of the Supreme Court cases?
Yeah, so Fourth Amendment is the big one, which is what the government can gather, the information that it can gather. And the Supreme Court said that the protection is that in order for the government to be able to engage in surveillance or gather information, it generally needs a warrant, which is a court order that is supported by probable cause. So the government just can't say, hey, we just want to watch everyone and gather whatever information we want or search your home. They can get it, but they need a justification. So they have to go to court. They have to say, here's why we suspect that we're going to find evidence of a crime where we're searching or where we're going to engage in surveillance. And the court then would decide, do you have enough justification? If you do, then we will issue an order so that you'll be allowed to do it. But it's there's oversight. There's making sure the government isn't just trying to do a dragnet, just like let's just watch and gather information and see what we turn up. And so that's the general protection. But the key question with the Fourth Amendment is, when does it apply? Because it doesn't apply to everything that the government might do. So, police officers walking down the street, and in front of the police officer, someone says, "Hey, I'm gonna dangle like cocaine in front of the police officer," and say, "Ha ha," the government can, they don't have to close their eyes if they see it in plain
You don't have a
sight.
warrant for this?
Yeah,
For
exactly.
this cocaine right here?
Yeah, so they can get it. But if it's searching your home, they need a warrant. Now, the tricky problem is, what do we do with digital technologies where, um, it's not like a physical search of the home. It's also not like, the waving the cocaine in the middle of in broad daylight. And the court made a fundamental mistake in the 1970s. And it held in a couple cases that when you gather information from a third party, people don't expect privacy in that information, because the test the Supreme Court uses is, does a person expect privacy in this? And is there a reasonable expectation of privacy? Is it reasonable?
Was this going through phone companies, or what was this? What were these cases?
Yeah, well, one involved a phone company, one involved bank records. So the phone company was, the government got a list of the numbers that a person dialed from their phone company, called a pen register. And the Supreme Court said, well, it's a third party has the information. When a third party has the information, it's not secret, and therefore you don't have an expectation of privacy. The bank records case, they got the bank records from the bank. And someone said, hey, they're private. I expect privacy in my bank records. The Supreme Court said, no, that's not a reasonable expectation, because the bank knows the information, therefore it's not secret. These decisions were terrible. And they really made it incredibly difficult with digital technologies, because with digital technologies, third parties know everything. They have access to all sorts of data about how you surf online and what websites you're doing. And even when you think you're anonymous, you're not really, because the companies can link you to your IP address. Um, uh, all sorts of information that we buy, but what we buy, well, credit card data, information from Amazon.com about all the books I'm buying and the products I'm buying. These days, I buy most of my stuff online. So, you don't need to search my home to find out what's in my house. You just can go to Amazon and find out what I bought from there. You can go to the different sites and go to my supermarket. I buy stuff through Instacart. So you go to Instacart. And
Wait, Professor, while you're on Amazon, maybe they should look for books by Daniel Solove.
Exactly. I have books there. But they can find, not just the books I buy, but also all the books I look at. All the videos that you watch online, all the websites that you visit,
even those ones you think when you're in incognito, like you said.
Yeah, I mean all of it, and this is the big problem. And so the court eventually, finally confronts this in a case called Carpenter, and it involves GPS information, location information, and the court finally says, you know what? If we extend the logic of the third party doctrine, which is what this is called, like if information is owned by a third party, you don't have privacy. They said, if we extend this information to everything, such as your location, we're going to learn a lot about you. And that's really privacy invasive. So we're going to say that people actually have a reasonable expectation of privacy in their location data that's collected extensively. Now,
Professor, is the Carpenter case, is that the one where police put a tracking device on a car?
It was actually getting the information from a company. So there's a case earlier called Jones where they stuck a device, and the court said, well, sticking the device on the car is the problem.
That's the trespass.
Yeah, exactly. And then I thought that was a kind of a silly, narrow way to decide it. And then finally the court in Carpenter said, well, it's not the device stuck on the car, it's the getting the data from the company that's the problem.
Got it.
So that's where the court said, the third party doctrine has limits. The problem that the court had is that its decision is very vague. It should have been bolder. Like if the court just said, you know what, we're just going to it should have just gotten rid of the third party doctrine because it just doesn't make sense. It doesn't really work. Just get rid of it and require warrants. But no, the court says, no, we're going to just say that this isn't the case. And then we're going to leave it open ended as to what is kind of like the location data and what isn't like the location data. We want to get data from Amazon. Is that like the location data or isn't it like the location data? How do we know? The court didn't give us a test or guidance for how to determine this. So that's where we are. And the court hasn't taken another Fourth Amendment case since then,
Interesting.
because that's hard. The court doesn't like doing stuff that's hard and coming up with reasons, especially this Supreme Court. It just doesn't like to do like hard legal work, which is you come up with real tests and reasons and you figure out how things should be and you articulate a clear rule of law that people can follow. That's what the court's supposed to do. That's why they're being paid the money. This
They're not
court
doing it
can
for
do
the
it.
money, Professor.
But that creates a difficulty because
Yeah.
now there's no real rule. No one knows what to do. And it's tough on everybody. It's tough on the police because they don't know, okay, when should we go and get a warrant? How do you know? And that's also, it leaves these loopholes, like, why the government is going to the data brokers and saying, oh, well, the Supreme Court held that we couldn't get the information from a cell service provider, so couldn't get the information from your phone company. So we'll just buy it from a data broker. Well, I think it's the same thing. I think, well, yeah, I think if you apply the general principle of the case, the government shouldn't be able to get the information by buying it from a broker. But
Interesting.
that's
If
what's
it was
going on right
impermissible
now.
to take, why should it be legitimate to purchase?
Exactly. But that's where the court didn't kind of clearly state what the real rules were. So we're in this place of uncertainty. And then the government's just trying to say, we're going to find another way. We'll just find a slightly different way and we'll do it. And,
Yeah.
you know,
Well, I could imagine those government lawyers saying, look, that's totally different. You have to go back to these extensive agreements that people sign when they sign up for that app that says, yeah, the company can sell it forward. And so, in essence, you've given up that right.
well, actually, no. So, I mean, first of all, I think those agreements are all bogus. I mean, I don't think people agree or consent to anything. They don't even read them. They don't know what they say. And
It's
so,
sort of cruel to expect you to be able to stop your day and spend an hour and maybe hire a lawyer to review every single thing that's then updated 10 days later.
exactly. And they're written by lawyers to be intentionally vague and unclear. So they're supposed to be that way because that's what gives the companies the biggest leeway in using the information. Uh, but take that all aside, the third party doctrine actually ignores those agreements. And so
Mm,
in cases even where a company were to promise in the agreements, like we do not share this information, we do not sell it, this information is private. The Supreme Court has said that they ignore contracts like that. And they say you still don't expect privacy, even if it's promised to you in
wow.
the agreement. And so you can't actually protect it through the contract. So it's kind of like unfair in a way to say, okay, the contracts can only count against you. So if the contracts say you don't have privacy, then we'll say, yeah, that gets rid of your privacy. But if the contracts say you do get privacy, we'll just ignore it. It's actually a pretty simple decision when it comes to privacy. It's a risk decision, right?
Mm,
Is using this technology or the benefits worse than, I mean, sorry, better than the costs. I mean, it's a cost benefit analysis. I look at the risks, like what are the risks to me? What bad things could happen? But what are the good things could happen? What are the, and for most of us, the equation is, well, the technologies are offering these immediate great benefits. Like, wow, I
yeah.
can hook my lights up to the internet. I can have a doorbell camera. I can use a cell phone and have this phone that does all these cool things, or really to like live in the modern world. it's hard not to use these technologies. It's like, okay, can you like not use the internet today?
Yeah.
So
Well, the doorbell camera one is such a great example. It's so practical if you want to decide whether to let in your Amazon delivery. But on the flip side, someone's basically having access to whoever, whenever you come and go from your home.
exactly, and that's the problem is that should it have to be this choice? Should I have to make the choice that okay, if I want to use the doorbell camera, I have to assume this risk that my information might be used in all these ways. Um, why does that have to be a choice? It's only a choice because the companies force it to be a choice, or the law
Mm.
allows it to be a choice. But the law could say, no, we don't think this is a choice or not. So yeah, when I drive a car, right? You could say, well, it's a choice. The car could just blow up on me. And I choose. I have to somehow consent to the fact of the risk of the car blowing up on me. Or if I want to eat food, I have to consent to the risk that it might kill me and poison me. And we say, no, that's actually not a fair choice. We won't allow that choice. We will mandate that the car won't blow up on you. And you don't have to decide, do I drive or do I blow up? Or when you eat food, you buy food in the supermarket, that it's not going to kill you. We assume that, the government makes sure that the food is safe. And, that's not something that I have to choose to barter away or risk my life to eat or drive.
Yeah, there could be added protections. Your point is that when it comes to privacy, they just aren't there.
Exactly. And that's the thing. If we treated privacy, I like to make this analogy to buying milk. So you go to the supermarket, you buy milk. And when you buy milk, I can look at what brands do I like, what tastes the best, and what's the cheapest, or what's the price do I want to pay. But I don't have to learn about become an expert on milk, or expert on pasteurization, or an expert on, I don't have to research the farms that the milk came from. It used to be different. It used to be the case where milk was laced with formaldehyde because it would spoil, and they mixed formaldehyde in it to sweeten it up, and all these babies would die. And eventually, the law developed to a point where it said, we're not going to allow these kind of things. We're going to make sure that milk is safe. And but with technology, it's like the old days. It's like 100 years ago where you walk in, you don't know, will the technology harm me? You've got to figure it out. You have to somehow become an expert on the technologies. You have to become an expert on AI. You have to learn exactly what these companies are doing and read, 30 minutes worth of a privacy notice written by lawyers designed to be impossible to understand, and then figure out if it's safe or not to use. And that's putting way too much onus on the consumer to do this.
Yeah.
Most people just want to go and they want to buy a carton of milk, and they don't want to become milk experts. And so why not with technology? I shouldn't have to become an AI expert to use AI.
Well, I want to talk a bit about something that AI does incredibly well, which is parse data at incredible scales. I mean, one of the biggest protections against government surveillance, or against the government keeping you under a microscope, is that it was just so costly. It was prohibitive in terms of manpower required to do that. But with AI and AI tech, we're reaching a world where surveillance at scale is actually a possibility. I mentioned up top some of the technologies that are basically starting to do that. AI wearables that track and listen to everything you say so that they can take notes or give you feedback later. There's uh, software tools that will help calculate next steps after business meetings. Are these types of things, do they present, I mean, obviously they're recording more of our lives. What do they do when it comes to our privacy?
Well, yeah, I think that, in the old days, surveillance was limited by the lack of people to parse the data. As you said very well, it was a limitation. But these days, AI algorithms can analyze the data and can flag certain patterns that are suspicious, and then send those up for review. So you don't need, we see those movies where, there's someone in the surveillance room and there's all these television monitors and they're watching
Right.
all this stuff going on. You don't need a person in the room watching anymore, right? The AI
Yeah.
algorithm's going to watch it all for us, flag those instances where there's something, and then serve them up. That means that all the surveillance cameras that we have now become much more invasive and much more problematic because now the AI is watching them much more intently, and the data can be used much more efficiently. And we've already have so many surveillance cameras out there, both public surveillance cameras that are installed by governments, uh, and also private surveillance cameras that are used by individuals, such as your doorbell camera.
Yeah.
And companies are
Or what
increasingly.
about these sunglasses that have cameras on them and, smart wearables that have outward facing cameras on them?
Yeah, I mean, now people are running around with cameras on them all the time. Oh, your cell phone has a camera, and people can record anything at any moment. I mean, I remember the days when you're walking out and something would happen, but you don't have a video cam
Yeah.
uh, or any camera to take a photo. Now it's like impossible not to record something or have something be recorded that happens because everyone's walking around with a camera and a video camera. With the glasses, it's just another, taking that to even another level where it just makes it a little easier to film and record things. But yeah,
You
we're going to enter an age where everything is recorded at all times. Uh, Audio, video, all recorded.
I'm trying to remember my, privacy section from my constitutional law class, but I feel like there was, a pretty clear understanding that if something happens out in public, you have no reasonable expectation of privacy. I feel like that resonated with me at the time, but now when I'm thinking about it, maybe you had no expectation of privacy if you're speaking loudly. But if you're talking to one person, or if you're sitting quietly and someone just has a telescopic lens with a recording device that can hear, you whispering to your friend, I feel like there you would have some expectation that what you said to your friend or your partner quietly would be held private between the two of you.
I think this is where technology has really changed things. I've never really liked this notion that if you're in public, you don't have privacy. I think it sort of forgets or doesn't really account for a certain dimension of privacy, which is obscurity. And when we're in public, a lot of times we are not like trying to hide everything away from the world, but we're obscure in that we're not expecting people to be paying attention. So you go, to the drugstore and you buy medications that could give rise to information about your health. But no one else cares. You talk to friends at a restaurant and you might talk about very private matters, but you don't think anyone's listening. There are a lot of things that people do every day, but they know that, hey, they're just a face in the crowd. No one's paying
Right.
attention. No one's recording it. No one's analyzing this, compiling it. But these days with technology, people can record all of this and compile it and single out a particular person and track them.
Right.
And that's the problem now, that we so much have depended on and didn't appreciate the obscurity by which we go about most of our lives. And that is being lost to this technology.
Professor, this is the first time I've thought of obscurity as a good. Our
Yeah. And it,
conversations make me look at it in new light.
exactly. It really is important. And there's some really great work by Woodrow Hartzog and Evan Selinger. They've written a number of pieces on the value of obscurity and the role it plays in our lives. And I think that we often take it for granted because, we've assumed that, this is how our lives work. But technology is now upending that, especially
Yep.
because there are cameras everywhere. But in addition to that, there's facial recognition.
Yeah.
And
How about facial recognition technology? Does that ping on your concerns? Is it something? Do you feel like when you walk into a drugstore that if your name popped up and it showed your conditions and all those things because maybe they thought that's good customer experience, or is that something that you think is dystopian?
I think it's very dystopian. I think that we depend on general anonymity every day, and not having people know everything about us. And, the idea that you could kind of go into a drugstore and you could buy whatever you wanted to buy. The store clerk wouldn't know who you were, wouldn't remember your name, wouldn't know your face, wouldn't know anything about you. You could buy it and it would felt private, right?
Right.
But now if they can pull up records of everything, if everything you do is tracked, and now all sorts of different companies know everything that you're buying and everything that you're doing, and AI algorithms can say, "Oh wow, you bought this, this, and this, so we think you have some disease." So I think there's something really lost when we're tracking all this information. And facial recognition means that, there really is nowhere you can go,
Right.
where you're not identified everywhere you go. And so there's an example where like there are these lawyers who were involved in lawsuits against, believe it was the
Madison
facial
Square
recognition.
Garden.
And they kicked the lawyers out. They said, "Hey, we don't like you because you're suing us, so you're not welcome here." And they used facial recognition to do that. And that could happen anywhere, right? You could, you walk into a store and they're like, "Hey, we don't like you because of your political beliefs, and therefore, you can't go into our store."
Right.
Whatever it might be. We don't like the fact of the pillow that you bought. So yesterday. So we're not letting you in to the store.
Professor, I'm going to give a couple of extreme hypotheticals, or a couple of hypotheticals, some more extreme, and you tell me whether under current privacy law they would be permitted. I'm trying to imagine something very extreme. Let's say the government outsourced its surveillance, short circuit camera to a third party, and so my company has cameras all over your city. It does a great job of monitoring any crimes and helping the police right those. What if I also, you know, say it wasn't in the contract with the government, but what if I also offered as a service, track your citizens? How many walks did Professor Solove go on in the last week? Check and see if he's getting his foot count in, and make sure that he's getting his exercise, something like that.
I think a lot of the laws, but not all of them, but a lot wouldn't apply because a lot of the laws exempt publicly available information. And so if it's in public, the laws are very limited, which is why I think that conception of privacy is wrong. It's not protective enough, and it's not really attuned to the world that we live in. So I think
Right.
that in a lot of cases, I wouldn't say all of them because privacy law is complicated and you have a lot of different laws and legal theories that could be applied. But I think in a lot of cases, privacy law would not provide adequate protection against it.
How about if I don't think I'm recorded, I'm out and about, and you and I are spending the day together, and I didn't know that you had a wearable that you used to record your entire life so that you could better take notes of all the brilliant ideas that you had extemporaneously and be able to plan out how to live in a more thoughtful and efficient way through conversations with your chatbot. But in the process, you've recorded a bunch of conversations that we had. Do I have any reasonable expectation that you can't then take that and publish it, or take that and, yeah, share it or use it against me somehow?
Well, most laws that doesn't fall under. So most laws you're going to be okay. There is a tort that's recognized in most states called public disclosure of private facts. This tort basically says that if you reveal private information about another person that's highly offensive, then that could in fact be something you could sue me for. Now, obviously, this is going to depend on a lot of factors, such as what did you say? It has to be highly offensive. So it has to be, pretty. So if you start talking about something very, very, very sensitive, like your sex life, then we could say, okay, that's highly offensive that I reveal that. What is the context? Like, where did I record this? If I recorded it in public, then courts might say, well, it's in public and therefore it's not private. Other courts might say, well, you disclosed it to me and therefore you shouldn't expect privacy once you're not hiding it anymore. But other courts might say, no, in fact, we recognize that, even if you share information with another person, that's a shared secret. There still is privacy in that. The information's highly offensive. The last element is that it can't be newsworthy. And
Oh,
so courts are again all over the place on this issue. If it's information a celebrity, were to say it, that's very different than if you said it. You're, probably a private figure. Someone
yeah.
like Taylor Swift, on the other hand, would have a lot less protection because people would say, well, anything about Taylor Swift is newsworthy.
Wait, so you have additional privacy for things that are deemed possibly newsworthy if
Uh,
you're a public figure?
Well, if you're a public figure, there is some guidance where, sometimes you have, courts saying, well, even a public figure is entitled to some degree of privacy, not everything. But you have others that will say, no, if it's someone like Taylor Swift, nothing is private. Everything is
Okay.
newsworthy. Um, and her whole life is of interest to everybody. And therefore, there really aren't very clear, easy rules here. When you look at the cases, makes it really tricky when I teach the cases to the students. The students say, "What are the rules?" And I say, "Well, it's kind of like you have one case that says this and another case that says something totally opposite to that, and they're just all over the place. And we really don't have good tests and rules for this, and so it's just a
Is
kind
it
of
because
luck of the
different
draw.
judges see things differently, or it seems that the facts of the case matter a lot in applying the doctrine?
The facts of the case matter a lot. These are all very contextual things, but also it depends on, what jurisdiction you're in and where are you and what the case law says and what the particular judge thinks. It really turns on that. And, you get, yeah, if you got judge me, I would decide things in a very different way than some other judge that might just say, look, hey, if it's in public or if it's a public figure, there's no privacy at all. And that's sort of part the fact that we really don't have a good consensus on what's private, and we also there isn't a good consensus on what's newsworthy, because some people think, okay, newsworthy should be something like about politics or something that's really, important, that goes to democracy or some big concept, whereas others will say, look, everything is newsworthy. What Taylor Swift ate for breakfast is newsworthy. Who she marrying is newsworthy. Everything about it. And look, we hear all sorts of stuff about her personal life. There are some people who would say, what Taylor Swift has for breakfast is more important than like what the Supreme Court has decided today. And that's
Yeah.
it's the people, everyone has.
Unfortunately, Professor, for our line of work, there's probably a lot of people who feel that way.
Exactly. And then who is to say what's newsworthy? So that person will say, well, you think the Supreme Court's newsworthy because, that's what you're interested in. But, I'm interested in Taylor Swift. And I think that's important for me. And who am I to tell them like what should be interesting to them? On the other hand, though, if we do that test, well, then everyone would say, look, they're interested in this and that. And then there can't be there's no test for newsworthy because it's whatever anyone wants to hear about. So it
I'm
just
thinking of the Gawker, I'm thinking of the Hulk Hogan case where Gawker published this sex video, and there were some very interesting privacy questions there. Maybe you could do a quick explanation of that.
Yeah, so it's a case, and it is a privacy tort case. Involved a video that was leaked about Hulk Hogan having sex, and he won that case. Even though he was a public figure, it was determined that this was not newsworthy. So it is one of the rare instances where a celebrity has won a case on privacy grounds for a public disclosure of private facts situation. That's very rare. I think it was also helped by the fact that, there was a lot of money pumped into his defense that helped that case. But I think I think it's going to be very
Into
hard.
his
Yeah.
lawsuit, you mean?
Yeah, exactly. And so, he had a lot of resources to bring the suit. One problem is that even though a private individual will have a little bit more privacy protection than a celebrity in that, they're not a public figure. The challenge for a private individual is that they don't have the same resources that Hulk Hogan has to bring the suit. And if
Right.
the information's disclosed not by a large mainstream media, but by just some blogger on the internet, it's going to be very hard for the person to bring a case because lawyers want a payday. And so if you can sue a big media site that has a lot of money, you're going to get a lot of payment if you win the suit. And that's how the suits work. But if you're just suing some blogger who has no money, what lawyer is going to spend the time to bring the suit if they're
Yeah.
not going to be able to make any money if they win? And
Yeah,
so
or if
for
you're
the
suing Jim, the guy who was next to you at the bar, who was secretly recording your conversation.
it's not worth bringing the suit. So
Right.
but then that's the problem. If one thing to sue a big media company, but if it's not a big media company and it's anybody, which is what technology now allows, right? It used to be before, Jim at the bar didn't have glasses that could record or didn't have a camera, or couldn't gather this information, couldn't get it out to the world. Now Jim at the bar can do that, but Jim at the bar doesn't have a big bank account. So when Jim at the
Yeah.
bar does this, what's your recourse? No one's going to bring a suit if there's no money to be paid.
Is there an expectation, Professor, under privacy law? Is there an expectation that someone alert you to the fact that they're recording you?
I don't think there's any expectation right now. I mean, maybe there should be, and maybe there should be something that does this. So, my camera, it has a light, and when it's on and it's recording, or it's on, the camera's turned on, it lights up. So I know when the camera's on, I know when the camera's off. And that's a neat
Right.
technology. And so it could be that you could, have the glasses where maybe the rims light up if it's recording, maybe the rims don't light up if it's not, so that people would know if they're being recorded or not.
I
Sometimes,
think the Ray-Ban ones, there is a little light in the corner that's on when it is recording. I imagine it wouldn't be hard to put something over it, but
yeah,
that exists.
and that's the but nothing mandates that they have to have this. So, I think maybe the law should mandate that there be a light or some indication that people are being recorded. Maybe one day there'll be technology where you could block yourself from being recorded. Maybe that I would have something on my glasses that would say, do not record. And I could have it set there. And so if you try to record me, I would be blank in your recording. That would be nice. But right now we don't have that technology, even though I think it's probably possible to have it.
Yeah.
Um, the technology develops based on, if we don't have the law directing the way technology develops, technology is going to develop in the way that suits the companies that make it. And they're aiming for what is profitable to us.
Got it.
That's the way they're going to decide it. If we want technology to be made in ways that are more privacy protective, the law, which is really society's way of saying, hey, we want you to consider other things more than your own profit. We want you to consider how to develop technologies that are going to protect our privacy and not, mess up our lives. Right now, what we're seeing is technology run amok, but technology could be developed in ways that are less harmful. So when the law says to car manufacturers, put in seatbelts, put in airbags, they do. And the law says we want these in because we want cars to be safer. We want cars to be more fuel efficient. So do this. We want furniture and clothing you buy to protect you against fire.
Yep.
We want medicines with caps that are, harder to open for children, even though the children can open it easier than adults. But we have these things because, the law says that there are other values involved that we should develop technology for. If you don't mandate that in the law, you get what
You don't
ultimately
get it.
you get what the rule of profit will produce for you. But
Right.
that doesn't mean that that's the good.
What about all party consent laws? Like I'm thinking about for phone calls. Some states, like California, may require that in order to record a phone conversation, they have to let everyone know.
I think those are good and bad. Um, I think they can be really good in certain cases, but I think that they're being misused in some states where people are trying to record the government, the police, or others in doing stops. And I think these are legitimate recordings. They're in public, in fact. But the ways the laws are written, it says that kind of any recording, even without, there's no exception for expectation of privacy. Anytime you record somebody without their consent, that could be a violation of the laws. And so in a number of instances, police that were engaged in illegal activity, brutality, in beating people up, etc., they were recorded. And instead of saying, when the recording came out, they didn't say, oh, well, maybe we should look in the mirror and reform ourselves. Instead, they said, oh, we're going to we're going to prosecute you who recorded it under the law that says that you can't do that. Now, that's a problem.
Really?
Yes.
And there are cases of this.
Yes, absolutely. And now some courts have said that's a violation of the First Amendment, so they struck it down. But I think the laws need to be amended to be very clear that, that it's the context in which this arises, that, these are not laws to shield the government from accountability. And that if you're recording, a government official doing something like this, that there is no, that the laws don't apply there. There should be an exception. And unfortunately, they don't have this exception. And so we're seeing these cases. And it's also why I think privacy is very contextual. Like it's hard to come up with like a one size fits all rule that anytime you record something like a conversation or an activity or anything else, that without someone's consent, that it's always a privacy violation or always something that should be prohibited. I would say no. In fact, there are a lot of instances where we might want that to be not prohibited and allowed. But there are other times where we want to restrict it. And it's not such an easy case to come up with a clear rule one way or the other.
I have a kind of a technical question, and maybe it wouldn't have an answer, but I'll throw it at you anyway. I'm curious if there was, let's say you're in a law that an all consent law for recording, would that apply for AI summaries? Let's say you had a technology that listened to the call and gave artificially intelligence driven notes, but did not save the transcript. Would that be a workaround?
Depends, because there's two different types of privacy torts and types of violations. There's a tort, and some of the laws will restrict information gathering no matter how it's used. So you don't need a disclosure. So just recording your conversation on illegally, for example, and under a wiretap law. So let's say I'm in an all consent state like California. I record our phone conversation, but I don't play it for anyone. I just like to keep them on my computer because I just enjoy having a permanent record. I don't use it at all. It just sits on my computer. That's still a violation.
Mm.
And so it's still a tort violation in certain cases too, to secretly record someone. Someone might say, I'm going to make these secret recordings. They have an Airbnb and they make a secret recording of people, but they don't post it online. They just keep it in their weird private, pervert collection. That is still a violation of privacy law and many different types of privacy laws. Uh, then there's violations for disclosure of the information. So if I take that information, then I disclose it, even if I'm not the one recording it, that could also be a violation. So there's a violation for gathering it, then there's a violation for disclosing it, and they're two separate things. Oftentimes they might occur in the same case, so you have both, but you can have one or the other, and you would have a violation.
How does the Wiretap Act play into privacy rights?
Well, the Wiretap Act generally, you have federal Wiretap Act, and then you have state Wiretap Acts. They're very similarly written in a lot of cases. The main difference is that some require all party consent, and the federal law just requires the consent of one party. So, for instance, if I'm on a conference call with 30 people, all it takes is one of those people to consent to the recording of that call, and it can be recorded. So the wiretap law generally protects against interceptions of a wire communication. This gets very technical, but basically any phone call, even a wireless call, is in fact considered a wire call because once it hits the cell tower, it goes through a wire. It only has to go through the wire at one point in time. So pretty much anything you do with your cell phone that records a conversation with the voice would trigger the Wiretap Act. And I'm simplifying, but that's roughly what the law is going to protect against. And it typically regulates without regard to an expectation of privacy. So unlike the Fourth Amendment, which says we're only going to protect conversations where you expect privacy, the Wiretap Act says we're going to protect any illegally intercepted conversation, even if I'm talking out in the middle of in public. So I could be on a train shouting into my phone, which people seem to shout in their phones on the train, right? Shouting into my phone for everyone to hear my conversation. And I wouldn't have a reasonable expectation of privacy in the conversation. So I wouldn't have Fourth Amendment. So if the government agent is sitting right next to me, no Fourth Amendment. However, I have Wiretap Act protection against someone intercepting that communication. If they actually intercept the signal and listen in on my conversation, that would trigger the Wiretap Act.
Got it. So if you're coming at my activities through this special intrusive way of listening into my phone calls, there are restrictions on it.
Exactly. And that's what makes privacy so tricky, is like the laws are triggered in very different ways. So we can't really say, okay, are my conversations protected? And I would say, well, that's a really tough question to answer. How is the data being gathered? People would say, is my health information protected? And I would say, well, it depends. It depends on, where the health information is gathered and stored. If your doctor has it, you have greater protections. It's going to trigger HIPAA. If it's health information in an app, that gets a lot less protection and depends on the privacy notice. It depends on the state that you're in. And it depends on the kind of information that you're disclosing. Is it health information or not health information? So someone's exercise information
Right.
may or may not be health information, depending on where you live. So this is what makes privacy really complicated, because I think for the average person, they just want to know, like, is my health protected? Are my conversations protected? What privacy do I have? And
Yeah.
the answer,
And now with wearables, I mean, there's so much information. Like, you might enjoy having your Whoop or your Apple Watch give you a sleep score every night, but maybe you wouldn't want everyone out there to know how much you slept or what time you went to bed every night.
yeah. And that's the problem. They're gathering all this information. And then
Yeah.
you throw it into a world where the law is kind of all over the place, and people have no way to figure out how private or protected that information is. Uh, so, it's really hard to say, to a person asks me a question, well, is that protected or not? Am I safe in using this app? And I say, heck if I know. because what state are you in? What data is it gathering? Does this qualify as health data under a particular state law? Who is gathering it? How is the company sharing it? Is the government gathering it from the company, or how is this going to? There's so many different variables and questions that have to be asked that it's really hard for an individual to figure out exactly what the risks are and the
Yeah.
implications are to the use of this data. And I think generally, if we want to protect privacy well, we need to have much more protective, restrictive laws where the general default should be it's protected and that it's restricted and that the company shouldn't have the information if they don't need it and they shouldn't be storing it forever. And there should be very strict restrictions on government access to this information.
Right. We talked a little bit about what being in public does to your reasonable expectation of privacy. You know, uh, Besides, I know that there's special rights in your home. Are there other places where you'd have a reasonable expectation of privacy? I'm thinking, a toilet or a priest's confessional box, those kind of places.
Well, we say generally yes, but let's go to the home, right? We say, do I have privacy in the home? Yes, technically I have privacy in my home. But a lot of that depends, right? People are living with roommates or in a home with other
Yeah.
people. The court has made exceptions where the police can walk in and they can just assume that, the person letting them in will consent to allowing them to search another person's room. And so the police often play dumb. They don't want to ask, like, is that your room? Can I search that? They just kind of go and they just do it. And they say, well, we didn't know. Someone let us into the house. So, um,
Mm. I've seen that in some TV shows.
yeah. And what I do in my home now is not that private because of the third party doctrine, right? So I'm in my home and I'm using my computer. I'm surfing the internet. I'm buying stuff.
Right.
I'm doing everything. And all that isn't very private. So the things I bought and that I have in my home now, it used to be that if someone wanted to know, like, what books am I reading? Um, do I have any books about Antifa on my shelf? They would have to search my home and get a warrant to search my home. But now you don't need the warrant to search my home. You can find out anything I've
Like,
read
just look on
by
on Amazon history or your what is it, smart reads or
exactly. So you can find all this out and you don't need to go into my home. Now, so do I have privacy in my home? Yes and no.
but maybe we'll move on to back to tech. And one area that's probably less in the news in the age of AI, but still something that's rapidly advancing is satellite technology. We're getting more and more satellites. They have better and better ability to zoom in and see what's going on in our day to day. And then with AI software, they have better ability to parse that. Are we moving into a world where not only is there no expectation of privacy in public, but it may be all searchable. It may be all accessible.
Yeah, absolutely. Ultimately, if we really, I think expectations are the wrong thing to look at. Because technology will constantly change and erode expectations. And ultimately, the reason why we have a test like expectations of privacy is the bigger question is when do we need legal intervention? When do we want the
Right.
law to intervene? And I actually think when we want the law to intervene is actually when we don't expect privacy, but we want privacy. So if we expect privacy and there's no risk to harm of privacy, then we don't need the
Mhm.
law to do anything. Where we want the law to step in is where we think that there's a risk, there's a threat to our privacy, and we don't expect privacy, but we should. We want privacy. We desire privacy. So I think whenever there's a reasonable desire for privacy, that's when the law should step in. That's when the law should say, okay, as long as it's reasonable for someone to desire privacy in this situation, we think socially it's a benefit to say, hey, we want to preserve people's ability to, sunbathe in their backyard do their, grill, whatever, without having, Elon Musk and his satellites figure out, what I'm grilling in my backyard and what I'm doing and record all that. Or some other company saying, well, we don't like the burgers that you're doing, and we want to now advertise, different food that you can grill on your grill outside. I think at that point we should say the law should
Yeah.
intervene and say, look,
Or undercut me when I go out to advocate for, you know, eating less meat. Showing that video of me making a steak in my own backyard to point out that I'm a hypocrite.
exactly. I think all that should be restricted, and the law needs to say, look, you shouldn't be able to use the satellites in this way. You shouldn't be able to gather the data, use the data. Um, that's something that the law needs to intervene to do, because otherwise it's just whatever someone who has a lot of money and can shoot satellites into the sky will be able to do and want to do. And unless, the law, which is society's way of saying, hey, you can't just do anything you want. There are other people and it can harm them and their problems. You can't use your satellites in this way. That's the only way to really have meaningful protection. Otherwise, what
This
we're
is
going to,
going back to your kind of framing that it only matters if I'm doing something wrong, that it's more about, autonomy or human dignity or some combination.
exactly. It's I think people should have the ability to live their lives, largely free of interference unless they're harming other people. And, if you start having people constantly surveilled, constantly second guessed, inundated with ads, everything about their lives being analyzed and scrutinized and recorded, they're not really free anymore. And I think that, the law needs to provide people with that space to be themselves, and to not be forced to live in an electronic fishbowl. But technology is moving to a point where that's, what life is going to be like, where, everything you do is going to be recorded. Everything you do is going to be seen, and there's going to be very little refuge for anything that you do.
Yeah.
Um, I'm not, we don't want that dystopia. And the only way to stop it is for the law to really aggressively step in. And unfortunately, the law's not doing that. Uh, and this is where we're heading.
If I had to think of one area where less privacy might yield benefit, I imagine that would be on safety. I think, no one wants to live in a community or a place where their home is at risk, where there's a likelihood of being robbed or assaulted or molested in public. You know, is there a way that some of these technologies can be used safely to reduce or increase our safety without overstepping on the privacy boundaries?
Yeah, I definitely think they're really beneficial uses to the technology. And so I'm not one who thinks, okay, we just ban all the technology. There's some really good aspects to use the technology. There's some good reasons why we want people to be able to record things. There's some really good instances of recording. It holds the government accountable. We see that happening right now, where the government is doing certain things and people are recording what's going on, and that is being, in the news, showing what's actually happening on the ground, which is helpful to actually have that being recorded. Uh, there, definitely want people to be safe, and we can use technology to try to address crime. The challenge is, how do we come up with a thoughtful balance so that we have technology used in ways that are helpful, but that don't unduly harm us? And I think we're going to see there's several types of cases. There are cases where the technology is mostly privacy invasive. It doesn't yield much security benefit at all. A lot of the security benefits are overhyped and overblown and are bullshit, basically. And those, I think, should be restricted. And they're pretty clear when you look at them. And then there are cases where, the security benefits are very, very clear. And it looks
Yeah.
like, wow, we really have security, and there are ways to use it that are not privacy invasive. And I think on those are easy cases. And then there are some cases in the middle that become trickier where, there are some security benefits, but there are also some privacy risks, and there might be some trade-offs. And then we have to decide, okay, in these cases, are the benefits worth the costs? How do we make that determination? And that's tricky because those are harder cases. But I do think there still are a lot of the easier cases. Yes, there are cases in that muddy gray area in the middle, but I think there's also clear cases on one side or the other when you look at them, and we can say, okay, these are the easy ones. Let's just knock out the easy cases. And then we're going to do the hard work to look at some of the tougher cases in the middle. And what we try to do in law is we try to figure out, okay, what are the principles that we're aiming for? What are our goals? What are our values? How much security are we getting? Are there alternatives to achieve the same goal that don't have the privacy trade-offs? Because maybe there are technologies or ways that the technologies can be controlled that will minimize the privacy aspects. Maybe they could be redesigned in certain ways to protect privacy. Maybe with the proper judicial oversight, that might be sufficient to provide the protections. There are a lot of ways, if we think about it, that we could, in fact, address the trade-off and have our cake and eat it too. But we have to do that thoughtfully. And unfortunately, what I see in a lot of legal debates is that it's not thoughtful. Instead, what you have are very overblown, absolutist arguments on each side that aren't really doing the hard, productive work of figuring out the right balance. But there really are solutions to be had. There are a lot of ways that we really could find meaningful, good policies that, most people could get behind, um, if we actually tried uh, to have a productive debate. And you can solve
Well, I
problems
think
this
this
way.
was a very productive conversation. Am I right that you have a kind of a hard stop around now?
Yeah, I have to run
All right.
very soon.
Professor Daniel Solove is a nationally recognized expert on privacy law and a professor at George Washington University. Thank you so much for the time. This was wonderful. I'd love to have you come back as things are developing in this high-tech world.
Well, I'd love to be back. Thanks for having me.
AI Lawyer is brought to you by the legal education website TalksOnLaw. For compelling attorney CLE, or for more free interviews and legal explainers with the titans of law, visit www.talksonlaw.com or join us again soon here on AI Lawyer.